A warm welcome from the heart of Munich at the Café Data protection. When companies want to assess the financial reliability of their customers, they often use programs to check creditworthiness and conduct a credit check. For this purpose, certain data is transmitted to credit check providers who then return the corresponding information on whether the customer is creditworthy or not. Naturally, numerous data protection regulations must be observed, which we will take a look at in today's video. The risk of payment default potentially exists when the company has to provide its own service in advance. Therefore, credit check processes should naturally and appropriately be limited to those transactions where there is an actual prepayment risk. To assess a person's creditworthiness, a so-called scoring model is then used. This means that the company transmits certain master data to a scoring provider who then compares it with the existing and previous data on the customer's credit behavior and provides information on whether, based on the previously available data, a payment default is to be expected or not. For carrying out such data processing, i.e., the transfer of data to the provider of such a scoring model, a legal basis is naturally required. According to the supervisory authorities, the so-called legitimate interest applies here when the selling entrepreneur makes an advance payment accordingly. Legitimate interest means that no explicit consent from the data subject is required. It is sufficient that a contract has been concluded which obliges one party to make an advance payment. In which cases can such a credit check be carried out? Well, we already mentioned it for all contracts that involve any form of prepayment obligation. These can be credit agreements, telecommunications contracts, installment purchase agreements, rental agreements. Anything where there is a prepayment risk on one side and a corresponding credit check can appropriately minimize this risk appropriately. When checking creditworthiness, only the data necessary for conducting the credit check may be transmitted. Keyword: transparency obligations. The affected individuals must be informed about the planned data transmission before the credit check inquiry. It must be made transparent to the affected person in advance that a credit check will be conducted and which data will be transmitted for what purpose. To paraphrase Aristotle, we cannot change the wind, but we can adjust the sails, and thus, a credit check is generally permissible if the entrepreneur has to make an advance payment. For the credit check, only those data that are necessary for the credit check may be used. This means that only as much data as necessary should be used, and the individual must be transparently informed about the credit check in advance. What else happened? In Berlin, there was a covert operation where facial recognition software was used from parked vehicles. More details can be found in the link in the description. Enjoy reading through it.